All right, this is the, are you here on Van Maren versus Davidson?
Yes, Your Honor.
You're next.
Jasmine Davidson is my client, Your
You're
Honor.
next. What's that? So
Yes,
I
Your
see
Honor.
Miss Davidson's here. And do I see Edward Van Maren?
Present in the courtroom, Your Honor.
All right, Edward Van Maren is present in the courtroom. So I have a motion for, sir, if you want to come on up, you can have a seat at this table. Oh, actually, you're going to be at that table over there, okay? All right, so I have a motion up for summary disposition. I've reviewed the motion. I've reviewed all of the documents that were submitted to the court. And is there anything that I need to be aware of?
Yes, Your Honor.
Your Honor, excuse me.
Wait, one sec.
Excuse me.
One sec. Can I get your appearance, sir? Can you tell me your name?
Edward Van Maren.
Okay, you can have a seat. Mr. Jaffe, give me your name.
Your Honor, good morning. Attorney Brent Jaffe on behalf of Jasmine Davidson. Your Honor, if I could address the court with regards to the motion that I filed. Your Honor.
Okay, so it's his motion for summary disposition. So Mr. Jaffe's going to go first, and then I'm going to hear your response, okay? All right, go ahead, Mr. Jaffe.
Thank you, Your Honor. The motion was filed, properly served on this individual. It was his poor decision to not retain a lawyer because he's not a lawyer and he has no idea what he's doing. That being said, he never filed a response, Your Honor. This is well over a month ago. And not only did he not file a response, Your Honor, but I just want to make state for the record, and I have verification, but I don't need to get into it. This might be one of the most.
Welcome back, everyone. Today, we're stepping inside Judge Shackleford's courtroom for a case that's equal parts baffling and dramatic. On one side, we have Edward Van Maren, a pro se plaintiff, meaning he's representing himself. And on the other, Jasmine Davidson, represented by attorney Brent Jaffe. What starts as a typical small claims dispute quickly escalates into a whirlwind of accusations, microtransactions, alleged fraud, and claims of emotional distress. Judge Shackleford, known for running a tight ship, is about to let this circus slide without scrutiny.
All right, I don't want any personal attacks. Let's just get to the meat of the case. What is your motion based on? And just get to that. You guys don't have to like each other.
Failure to state a claim, Your Honor. This individual has never presented an iota of evidence to substantiate any claim that he's ever made, but rather this lawsuit was just an attempt for him to defame and harass my client. But again, Your Honor, no response. And respectfully, Your Honor, I would ask that this court hold this person to the same standard that an attorney would be held to. I would ask that my motion be granted accordingly, and this case be dismissed.
Sir, do you have a response?
Yes, Your Honor, I do. First and foremost, I was under the impression that defense never bothered to file an answer to this case to begin with. Moreover, as defense is trying to claim, my attorney was never present during the said case, the previous custody case between defendant and myself. I have been.
So let me ask you this. Let me ask some questions. The parties were you married or dating?
Dating.
All right, so how long, when did you start dating?
We were together 5 years.
When did you start dating?
2018.
When did you split up?
22.
Okay, so you split up in 22. Your allegation is that this,
If I may, Your Honor, we started in 17, not 18. Our daughter was
Okay.
18.
Okay. So basically the allegation is that a bunch of these miniature charges were made at the time where you two lit these charges for like $3, $2, $1. I don't know if these are all like phone games.
That's exactly what it was.
Okay, it looks like phone games to me. So these were all charged at the time the two of you were you living together?
Yes, Your Honor.
All right, so you were living together, you were cohabitating.
Yes, Your
Who
Honor.
was working?
I was.
Okay, and Miss Davidson, did you have an infant at that time?
All right, let's pause for a second here. We're right as attorney Brent Jaffe is laying out the defense's motion for summary disposition. In plain English, he's basically saying, This lawsuit has no merit. The plaintiff didn't file proper responses, and frankly, is an attempt to harass my client. Notice how Jaffe highlights not only procedural issues, but also the disrespectful behavior he claims from Van Maren. The attorney is setting the stage to show the judge that the plaintiff isn't following legal rules, which is crucial in these motions.
So is it a baby at this time or a young kid? I mean, there's no year on ISC like 1106, 1217, 5320. But it didn't tell me the year these charges were made. Like, I can't tell from looking at the documents that were submitted when they were made. It just says year, or it says month and day.
That is fair, Your Honor, and I do have a stack of papers more than an inch thick of 4 years of bank records. I would be more than happy to bring to the.
Were you guys living together at that
Yes, Your
time?
Honor.
Okay,
But the
so.
record also showed that she emptied my checking account while I was providing for both her and a minor child. One of those instances occurred while I was at a grocery store with a shopping cart full of stuff, and she still emptied my checking account.
All right, but there's no claim for that in here. I mean, I just see the claim is that I don't mean to call them micro
That's
transactions,
exactly what they are.
but they're like $1.05, $1.05, $4.69, 91 cents, $1.05.
Several hundred in total.
These are, well, then what is you made a claim for 6,500.
Yes,
What is-
Your Honor, and if I may also point out that during the custody agreement, when we were ordered by the court week on week off custody on a dozen separate occasions, I made verbal agreement, which I'll quote Pennzoil v. Texaco, and that verbal agreements are enforceable. I made a verbal agreement with defendant to take child on defendant's court-ordered scheduled week so that she could go out with friends in exchange for her to do the same on my week, and I was robbed of that a dozen times on my weeks.
Here's where things start to get messy. Edward Van Maren jumps in, claiming he's been wronged during cohabitation and alleging his ex drained his finances. Over $6,500 in what he calls microtransactions. Keep in mind, these are transactions like a few dollars here and there, but he's framing it as a massive fraud scheme. The judge wisely questions the context. These purchases happened while the couple lived together, and she was the primary caregiver for their child. Right away, you see the tension between personal grievances and what the law can actually enforce. For the audience, this is a huge lesson. Emotions and feeling wronged don't automatically translate into winning a lawsuit.
$6,500 of claim damages for a bunch of micro transactions that equal hundreds of dollars. And those transactions all occurred during the course of your cohabitation while you were the primary caregiver.
Yeah, Your Honor, that is correct, Your Honor. That is correct, Your Honor. And again, just to reemphasize that, again, not an iota of information or supporting documents or even be Texaco, whatever the legal scholar is quoting, has ever been presented to me, nor has this person ever contacted me. Again, he was rightfully served, Your Honor.
Well, it doesn't matter. I mean, if they're talking about making agreements outside of their parenting time order and one party's honoring them and the other party isn't, I am a district court judge. I do not do family law. I am not going to overstep my bounds and get involved in that. And certainly, I'm going to tell you my honest thoughts. I did family law for a long time. And if you two can't figure out how to get along on some level, you're going to screw your kid up. I'm just telling you, that's how it is. That's what I see here. And I see it all the time. And it's really disturbing to me because if you two talk poorly about each other, get mad at each other, in front of the child, can't communicate with each other, you are messing a kid up. You are. And I mean, and that's a family law matter. It's not in front of me, but
And Your Honor, I did represent.
I'm very sad to see it over and over and over again. Sir, do you have any other documentation that you want me to look at?
Your Honor, if I could actually go back to the motion in which defense made an effort to claim that my counsel never appeared.
Why do I care?
Now, Judge Shackleford steps in with some common sense that cuts through the noise. He reminds the parties that this isn't family law court. He won't be ruling on child care agreements or settling personal disputes. His point? The focus is on whether there's a legal basis for the claim, not who's right or wrong in daily life. He even gives a subtle reality check about the long-term impact on their child if conflicts aren't resolved responsibly. This VO highlights the judge's ability to remain impartial while gently educating both the courtroom and us, the audience. And let's be honest, anyone watching can feel the tension here. These are the moments that turn a standard courtroom scene into compelling content.
No, he's saying, no. Listen, he is trying to get your case thrown out by saying there's no relief and there's no claim, that there's no legal basis for your claim.
So.
Is that you failed to state a claim on which relief can be granted. So I keep asking you, what matters to me is what documentation do you have that she owes you $6,500?
Your Honor, would a couple write a contract for who's gonna pick up children from school any given day of the week? No, most couples are not. So in the same sense, if a couple is together and one party owes the other money, are they gonna write a contract?
Yeah, the answer is
No, and when one of the so are you charging her for food she ate while she was the primary caregiver for your child and you were at work? Is she have to pay you back for the food she ate?
I'm asking
You a question, and guess what? I got the robe, sir. So I'm asking you a question. Does she owe you money for food, shelter, clothing that you paid for her while she was the primary caregiver for your child?
Your Honor, she does owe me for food, clothing, and shelter. During the 10-month span that I was under false pretenses, we were going to be a family.
The request for relief in this case was the maximum that was allowed in district court in small claims. It's since been removed, but the amount claimed was $6,500. And the allegations were credit fraud, defrauding by means of solicitation of prostitution, possession of stolen property, promissory fraud, and
Back to Van Maren, who now gets into specifics: alleged theft of $6,500, manipulation of custody agreements, and claims of fraud. He's even arguing for reimbursement for basic necessities like food, clothing, and shelter. But the judge is skeptical, and for good reason. From a legal standpoint, when a couple lives together and shares expenses, courts generally don't allow retroactive reimbursement for everyday living costs. This segment is pure courtroom drama, but it's also a masterclass in understanding the limits of civil claims. For viewers, note the disconnect between Van Maren's passionate argument and the legal framework the judge must apply.
I do have several hundred hours of audio recordings held within my own home, as the Exhibit A submitted by the defense shows that the defendant was made aware that everything in my home was being recorded.
Your Honor, may I address the court briefly, Your Honor?
very brief.
Thank you very much, Your Honor. As a practical matter, I represented my client also in the custody matter for like over the period of like almost a year. And respectfully, Your Honor, I'm not sure why this plaintiff feels he has a platform to do it. Your Honor, again, there's no relief has been, nothing's been substantiated, Your Honor, and they actually took this serious, which I don't think he is. And again, I think it's a pure harassment technique. And he would have hired a lawyer, because that's why people pay a lot of money to go to law school.
All right. I mean, listen, Mr. Jaffe, we don't have to get in the mud though. Like, listen, as far as I'm concerned, I don't see any claim that relief could be granted on. I mean, all of these, when you have two people and look at, I'm going to just use common sense and reason. When you have two people who are cohabitating with a minor child, an infant, or a very young child, what year was the child born in? 2018?
February 2018.
So we're talking about a kid who is not school age,
Correct.
right?
She's 5 now.
She's 5 now, but all of these purchases, all of these, what I'm calling microtransactions, all occurred while the two of you were in a relationship, while the two of you were.
Now we enter the infamous microtransaction debate. Van Maren frames his ex's mobile game spending as massive financial harm. Judge Shackleford isn't having it. He points out the absurdity of claiming thousands of dollars for minor digital purchases made during cohabitation. The commentary here is both dramatic and educational. This is where we see the court applying reason over emotion. It's also a perfect example of how digital age disputes can spiral into legal chaos. For the audience, consider this. How often do we see social media or tech purchases blow up in real life? This is why context matters. And the humor here? Comparing unpaid daycare and household management to being a live-in service provider.
In a relationship while she was the primary caregiver. And there are agreements that are made. I mean, you can look at it with common sense and reason, which is what I'm doing. And we're talking like, look, she likes phone games a little too much. I'll give you that, but you can't come a year and some after the parties split up and claim $6,500 in an action because of transactions that occurred. She clearly had access to money. Did your client go to the grocery store, Mr. Jaffe?
Of course, for the family, of course.
At the time, no, Your Honor, she did not. She did not
Your
have a
Honor,
license.
absolutely. And again, Your Honor, this is
Wait,
yes.
I have a court recorder. Do not make her suffer. She cannot type both of you at the same time. Okay, so you're telling me, Mr. Van Maren, that she did not ever have access to any bank account?
She had unlawful access to mine when she saved my credit information in her phone without my permission.
Okay, wait. So the whole time you were together.
My grandfather took me shopping.
So she was never allowed to go to the store or make any purchases?
She went with me.
So she had no access to money. It's your statement. This is what you're telling me. She had no access to any money at all while she was staying home with this minor
She
child.
couldn't be trusted with money, obviously.
Okay, all right. I find that there is absolutely the plaintiff has failed to state a claim on which relief can be granted. We're talking about microtransactions that occurred during the relationship between the parties where they resided together and had a minor child, and Ms. Davidson was the primary caregiver for said minor child.
Your Honor,
Obviously, sir. If you want to file an appeal, sir, you are certainly entitled to that relief.
As the case continues, Van Maren references hundreds of hours of audio recordings and bank records, attempting to substantiate his claims. But Judge Shackleford focuses on procedure. Has the plaintiff actually proven a legal claim? The judge repeatedly asks for concrete documentation, emphasizing that emotional arguments, personal grievances, or anecdotal evidence won't suffice. This VO is critical. It demonstrates the distinction between what feels like justice and what the law actually enforces. The audience gets a front row seat to how procedural rules can make or break a case. And notice the pacing here. Each interruption, each question keeps tension high while clarifying the stakes. So let's wrap this up. Judge Shackleford has consistently reminded both parties. The court cannot enforce personal disputes about cohabitation, childcare, or shared expenses after a breakup. While Van Maren's claims are dramatic and filled with emotional intensity, they fail to meet the legal standard for relief. This case underscores two key takeaways. First, pro se litigation is incredibly difficult, especially against experienced attorneys. Second, courts prioritize evidence and procedural correctness over feelings and frustration. For our viewers, it's both a cautionary tale and a lesson in legal reasoning.